Hello friends and welcome to my channel. Today we are going to discuss the most important case law of Indian Contract Act 1872. This is really very important case law and this is the maximum probability case law which can come in your examination. So guys, don't skip this video. Watch this full video till end, and there are four case law which I have discussed in this video, and I think that any of the four case law may come in your examination, or any of the case law on the basis of this case law may come in your examination, because this is really very important case laws. So without wasting time, just start this video. If you want to watch the same video in Hindi, so there is an annotation running on the top right, just click on the annotation, otherwise there is a link in the description box. Case law number 1. Ravi sent a consignment of goods worth rupees 60,000 by railway and got a receipt. He obtained an advance of rupees 30,000 from the bank and endorsed the delivery and endorsed the railway receipt in favor of the bank by way of security. The railway failed to deliver the goods at the destination. The bank filed a suit against the railway for rupees 60,000. Decide in the light of provisions of the Indian Contract Act 1872. Here has been 1862. This is Contract Act 1872, whether the bank would succeed in the said suit. So what is happening here? Ravi has sent some consignment. The consignment cost is rupees 60,000 and got a railway receipt by railway. And at the same time, he obtained some advances of rupees 30,000 from bank. Okay, and he endorsed the railway receipt. Okay, so means he kept the railway receipt by way of security. He deposited the railway receipt to bank and he obtained 30,000 rupees from the bank. Okay, so but railway failed to deliver the goods, so you have to just discuss as per the provisions of the Indian Contract Act. Answer is deposit of title deeds with a bank as security against an advance constitute a pledge. So this is a case of pledge, means the Ravi has deposited his 60,000 goods receipt to the bank. So means he has pledged his 60,000 goods to the bank. So this is the case of pledge. Now, if the third person wrongfully deprives the pawnee of the goods or damages of the goods, the pawnee is entitled to all the remedies as the owner might have exercised as if the goods were not pledged. So the section is section 180. But in case of pledge, the pawnee can exercise all the rights which a pawner could exercise in respect of such goods if those goods are damages or some third party deprives the pawnee of such goods. So the case law is Mavi Mercantile Bank Limited versus Union of India, and in this case compensation received by the pawnee shall be divided among the pawner and pawnee as their respective interest. The section is 181, and the conclusion will be the bank shall pay over to Ravi rupees 30,000, means 60,000 minus 30,000. Okay, so already he have taken 30,000, so 60,000 minus 30,000 the bank shall pay to Ravi. Next is case law 2. This is guys revisionary video for this case law. Case law 2. A contracted with B to supply him 500 tons of iron steel at the rate of 5,000 per ton to be delivered at a specified time. Thereafter, A contracted with C for the purchase of 500 tons of iron steel at the rate of 4,800 per ton, and at the same time told C that he did so for the purpose of performing C contract entered into with B. So what is happening here? First of all, A contracted with B to supply at the rate of 5,000 per ton, and he needed goods to supply, so he contracted with C to purchase at the rate of 4,800. Means A is getting benefit of 200 rupees, okay, per ton. So here is 500 tons. Okay, so means the benefit he could get rupees 1 lakh rupees of benefit. Okay, so now what is happening? C failed to perform its contract in due course. Consequently, A could not procure any iron steel and B resigned the contract. What would be the amount of damages which A could claim from C in the circumstances? Explained with reference to Indian Contract Act 1872. So we have to understand, we have to just explain that what can be the claim, okay, that A could claim on C. Now the answer is, since it was within C's knowledge that breach of contract by him would result in non-performance of the contract between A and B, resulting in loss of rupees 1 lakh rupees. Okay, 1 lakh rupees means 5,000 minus 4,800 per tons at the rate of, okay, 500 tons to A. So 500 minus 4,800 is equal to 200 rupees multiplied by 500 tons is equal to 1 lakh rupees. So the section is section 73. Case law number 3. Examine whether the following constitute a contract of bailment under the provisions of Indian Contract Act 1872. First one is V parks his car at a parking lot, locks it and keep the keys with himself. So he kept the keys with himself. Second one is seizure of goods by custom authorities. So what happens if there is any issue with the custom? So the custom authority will seize the goods and he will keep with himself. So seizure of goods by custom authorities. So answer would be, first of all, 1. Parking the car and keep keys with himself. This does not result in a valid contract of bailment because since delivery of goods does not place stake in such a case. Okay, because he just kept his keys in his pocket, that's why there is no any delivery and there is no any contract of bailment. In second case, seizure of goods by custom authority result in a valid contract of bailment since all the essentials of valid contract of bailment are satisfied in such case. Next one is case law number 4. M lends a sum of rupees 5,000 to B on the security of 2 shares of a limited company on 1st of April 2017. On 15th of June 2017, the company issued 2 bonus shares. B returned the loan amount of rupees 5,000 with interest, but M returned only 2 shares which were pledged and refused to give the 2 bonus shares. Advice be in the lights of the provisions of Indian Contract Act 1872. So he did not return that bonus shares. So we have to decide where is he entitled to receive the bonus shares or not. So the answer would be B is entitled to the 2 bonus shares because since the bailer is entitled to any accretion in the goods. So if there is any accretion in the goods, so bailer is entitled since the issue of bonus shares by the company amounts to accretion to the goods and he will entitled to receive the bonus shares. So guys, this video was till here only. If you have any doubts, so just write me. This is my YouTube channel, youtube.com/c/Ravindra Ojha. Otherwise you can comment below this video also. Any issues, just write me down over there. Thank you so much guys, and if you have not subscribed, please subscribe this channel and press the bell icon so that you could get all the notifications of my uploaded videos. Thank you so much guys and have a nice day.